My name is Michael Kessler. I'm the Managing Director of the Berkley Center for Religion, Peace, and World Affairs at Georgetown, where I teach in the Department of Government and the Law School. I'd first like to thank Tom Farr and Tim Shaw and the leadership team of the Religious Freedom Project for putting on yet another stellar event, and to thank our partners of the Religious Freedom Project at Baylor University, President Starr and Byron Johnson, and the team who are excitingly going to be joining us for this inquiry and venture over the coming few years. Greetings to you in the audience. Our discussion here today is part of a wider conversation about important issues of healthcare needs and costs, individual liberties, contested social, personal, and communal goods, and the way to balance these pursuits with cherished protections for equality under law and religious freedom. The Berkley Center has held previous discussions about the regulations implemented by the Department of Health and Human Services under the Affordable Care Act, and the claim that they create violations of religious freedom. Previous conversations have focused on questions about how religious communities and not-for-profit religiously affiliated institutions such as universities and social service agencies are impacted by the law. Those events are on our website and rich with information, and I submit that you would be well served to check them out. Today our focus is on the claims by some that for-profit corporations are impacted by the ACA's so-called contraception mandate, that it violates the religious freedom of corporations and their owners. These are extremely complex legal and political questions, and with all respect due to President Starr, this panel will actually really dig into the boring legal questions that he touched on very eloquently and wanted to push past. So that is the charge to the committee assembled in front of you. I suspect there will not be consensus emerging among the panel or the room about how the case should be decided, but I submit it is a worthy goal unto itself and a most crucial goal for our democratic order, that we come to a better understanding of all of these issues, better understanding of how each of us come to the table, finding them to be vitally important. I also think it's safe to assume that if you're here today, you're familiar with some of these debates. But here are a few quick facts to refresh your memory. In August 2011, the Department of Health and Human Services issued an interim final rule as part of the implementation of the Affordable Care Act that indicated that they would require most health insurance plans to cover preventive services for women, including some forms of contraceptive services, without any copay, co-insurance, or deductible. The rule authorized the Health Resources and Services Administration to exempt, quote, certain religious employers, and yet define this narrowly. And as you know, the debates in the last 2 years were about who got an exemption, who then didn't get an exemption but got accommodations, and who, at the end of the day, didn't get any accommodation. The debate, while strenuous over the role of nonprofits, was also there was also strenuous debate over the role of for-profit corporations and businesses. Over the strenuous objections of some for-profit employers like Hobby Lobby and Conestoga Wagon, the government did not implement any mode of accommodation for religiously objecting for-profit businesses. The respondents in the current case, on appeal in the Supreme Court and scheduled for oral argument tomorrow, claim that the preventive services rule, quote, substantially burdens their exercise of religion under, and I can now just say RFRA since that was introduced in the last panel, under the Religious Freedom Restoration Act, if you're newly joining us. Their claim in a nutshell is that the ACA requires them to offer their employees access to a medical insurance plan which must include coverage of abortifacients, certain kinds of contraception that are claimed to terminate a pregnancy. In providing this coverage, the individual owners of the companies they claim are forced to provide among other things, provide access to and pay for the use of abortion-causing drugs and devices. And this violates their religious beliefs by making them complicit in their employees' eventual use of abortifacients. How do we assess this claim of burden? Other questions that we will address include if the government has, through the legislative process, deemed it essential to cover the kinds of services that HHS determined are important for public health care. How does it matter if some citizens, including corporations, claim that these services would violate their conscience and religious belief and identity should they have to participate in the provision of those services? How is a regulation like the HHS mandate a violation of religious freedom for corporations as opposed to private individuals? How should the state respond to this claim of a substantial burden? Does the current state of religious freedom law necessitate or merely allow for accommodations? And if so, are those accommodations given only in the legislative process, or is there a judicial remedy? In other words, does RFRA apply here to for-profit corporations? If exemptions are granted, where do they end? Professor Dershowitz posed a challenging question, which I'd hope to take up at some point in the panel. Can gender, race, and other factors also be the basis for religiously based discriminations that are now to be provided exemptions by for-profit businesses? My last point before introducing and turning this over to the panelists is to provide a bit of background for why this case hinges on the Religious Freedom Restoration Act and is not primarily a constitutional case about our nation's so-called first freedom. Judge Starr did go through a few of these points, but this is sort of in the nutshell in order. Starting around 1963 with the case Sherbert v. Werner, the court began to implement protections under the Free Exercise Clause whereby persons with sincere religious objections to government laws had a presumptive First Amendment right to an exemption unless the government interest, subjected to so-called strict scrutiny, was found to be the least restrictive means of serving a compelling government interest. Then came the infamous 1990 case, Employment Division of Oregon v. Smith, under Justice Scalia's majority opinion, which delivered a blow to the scheme. If a law is neutral, that is, not directly discriminatory against religious believers as such, and generally applicable, then it is valid constitutionally, and religious objectors do not generally get an exemption. Justice Scalia pointed to the legislative process as the available avenues for religious objectors to gain redress. Build the exemptions into the law at the start, and the exemptions will be all the stronger for being the result of the political process, not enacted through a judicial fiat. Condemnation of this decision was swift and came from all sides. As President Starr noted, it may be the last unanimous act of Congress signed by a president in my memory, which attempted to restore the statute, by statute, the presumptive right to exemptions from generally applicable laws. As RFRA put it, quote, "Government may substantially burden a person's exercise of religion only if it demonstrates that application of the burden to the person is the least restrictive means of furthering a compelling government interest," end quote. The court overturned RFRA as it applied to the states in the 1997 case, City of Bernie v. Flores. Very fascinating case, which I recommend you take a look at. But for federal matters, it still applies. And the implementation of the Affordable Care Act thus is subject to the provisions of the Religious Freedom Restoration Act. Up until these cases, though, none have dealt with the question of how for-profit corporations might claim a substantial burden under RFRA. So our questions are clear. This is a legal panel that will deal with these legal issues. Now I will introduce our esteemed panelists who will make more clarity available to us about these complex issues. First, Helen Alvera is a professor of law at the George Mason University School of Law, where she researches and writes about family law and the intersection of family law and religion. As a practicing lawyer, Alvera specialized in commercial litigation and free exercise of religion matters. She drafted amicus briefs in many leading U.S. Supreme Court cases on behalf of the Office of the General Counsel for the U.S. Conference of Catholic Bishops, and later worked for the USCCB's Secretariat for Pro-Life Activities. Alvera chaired the commission investigating clerical abuse in the Archdiocese of Philadelphia and is an advisor to Pope Benedict XVI's Pontifical Council for the Laity and has served as an ABC News consultant. Kyle Duncan, until recently, was general counsel at the Becket Fund for Religious Liberty, where his work included representing Hobby Lobby and the Green family in Sebelius v. Hobby Lobby. Kyle is now in private practice pursuing these sorts of cases. Previously, Duncan served as Louisiana Solicitor General from 2008 to 2011, where he argued numerous appeals in state and federal courts, including the U.S. Supreme Court. From 2004 to 2008, Duncan was an assistant professor at the University of Mississippi School of Law, where he taught courses on constitutional law, church-state relations, and free speech. He was assistant solicitor general in the Texas Attorney General's office from 1999 to 2002. Ira Chiplupu is the F. Elwood and Eleanor Davis Professor of Law Emeritus at the George Washington University Law School, where he was on the faculty since 1990. Lupu's research focuses on constitutional law with an emphasis in his writings on the religion clauses of the First Amendment. Together with his colleague, Robert Tuttle, Lupu is the author of a series of annual reports between 2001 and 2008 on the faith-based initiative of President George W. Bush, and the author of many other articles and books, including the forthcoming book from Erdman's Secular Government, Religious People. Micah J. Schwartzman is the Edward F. Howry Professor of Law at the University of Virginia School of Law. Schwartzman's research focuses on issues of law and religion, jurisprudence, and political philosophy. Prior to joining the faculty at Virginia, Schwartzman clerked for Judge Paul V. Niemeyer of the United States Court of Appeals for the Fourth Circuit, and was a postdoctoral research fellow at Columbia University's Society of Fellows in the Humanities. Schwartzman went to Virginia for his undergrad and law degree and received a DPhil from Oxford, where he was a Rhodes Scholar. So, before I ask the first question and take a seat, could you please make sure that all of your cell phones and other noise-making devices are turned down so that we don't disturb the flow of the conversation and others' attention? So the first question, I think, was perfectly teed up by Judge Starr and by Professor Dershowitz. What is the substantial burden that is claimed? How do we cognize that legally? Kyle,
I'll take it, Michael. Okay. Thank you. And thank you for having me on this great panel. You know, as Michael indicated, I had the privilege of representing the Green family in this case in the 10th Circuit, and I see them here today, and I thank them for coming. You know, you said this case is very complicated, and it is complicated in many ways. It brings into its ambit a number of different issues, not the least is the whole issue of corporate free exercise of religion. However, on the other hand, this case is quite simple. You ask about substantial burden. So as everyone knows, RFRA, the statute, the civil rights statute at issue here, says that if government substantially burdens a religious exercise, then the government has to meet the highest standard known to constitutional law to justify that burden, or strict scrutiny. What triggers RFRA is a substantial burden. And you ask what a substantial burden is. From our point of view, the substantial burden question has always been really childishly easy. That if you force someone to do something contrary to their faith, and you say, if you don't do it, we'll fine you, or if we don't fine you, we'll make you completely restructure and disrupt your business, then by any definition known to constitutional law, that's a substantial burden. So what we've always said in this case is substantial burden is very simple. It's the pressure that the government puts on someone to violate their faith. You know, and I have this brief here, and I think I'll just read you, 10 or 12 pages from the brief. No, I don't think I'll do that. So what we say is substantial burden is pressure. So, the Sherbert case. The Sherbert case from the 60s said if you tell a Jehovah's Witness you can have unemployment benefits, provided that you agree to work on Saturdays, which happens to be your Sabbath, you can have the unemployment benefits. That creates a lot of pressure on someone to say, yeah, you know, maybe I misinterpreted my religion, and maybe I really should go to work on Saturdays. That's substantial pressure, right? And Sherbert said, if I tell you, if you work on Saturday, I'm going to fine you, then that's a paradigm substantial burden. Very easy. It's substantial pressure. That's what we say in our brief in the Hobby Lobby case. Here's what the government says. And it's brief, because when I got the government's brief, and I thought, oh, good, I get to find out what the government thinks a substantial burden is. This will be great. We can argue about it. Here's what the government says, and I quote, "A proffered burden may be deemed not substantial in cases where the nature of applicable legal regimes and societal expectations necessarily impose objective outer limits on when an individual can insist on modification of or heightened justifications for governmental programs that may offend his beliefs." Now, I don't understand what that means. None of you do. And I bet that the Supreme Court justices don't understand it either. In other words, the government has no test. They throw out a bunch of principles and say, well, it's not a substantial burden here because there's distance and attenuation between the owners and the actual use of the contraceptives, or because there are third parties involved. But there's no test there. So from our point of view, it's a very simple case about substantial burden. It's pressure. It's not a religious inquiry. It's not asking what the theology of the Green family is or whether it's material cooperation or remote material cooperation, none of that. It's the pressure the government puts. And the pressure here is very clear. Do something that offends your beliefs, or we fine you, or we make you totally disrupt your business. That seems to me to us to be very clear.
Chip? You can see that the older folks who've been here today are going to tell some stories, okay? Alan Dershowitz, Ken Starr, they had some stories. I have a story about RFRA that I want to tell before I get into the substantial burden piece. That's what you asked about, and I'll come back to that. The story of RFRA is not nearly so simple as the way in which it was told and the way it unfolded in the remarks this morning. The law of the Free Exercise Clause before the Smith case in 1990 was not simple, straightforward, Sherbert and Werner, Wisconsin and Yoder, substantial burdens, compelling interest. This is the way it always goes, right? This is the oversimplified narrative, is that there was this really protective law of religious freedom, and then the Smith case blew it up, and the Religious Freedom Restoration Act just put it back, restored it. But if you paid attention to what the Supreme Court had done before 1963, but also between 1963 and 1989, you will see a whole long line of cases. We'll talk more about some of them later, about civil, having to do with civil rights laws, having to do with Social Security, having to do with minimum wage laws, having to do with religion in prison, religion in the military. Over and over and over again, the religious liberty claims in those cases lost. And you won't see any rigorous application of this substantial burden, compelling interest test. So when the Smith case made the move it made, it changed something important. We're not disputing that. But what happened in Congress was a legislative coalition of folks, which, important footnote, excluded right-to-life folks at first, okay? A very important, some of the folks who were really on the side of the Green family here were not on the side of RFRA in the first 2 years between 1990 and 1993. But the folks who came together and said, oh, a terrible thing has happened. We need to restore religious freedom. We're going to put it together, a statute that reads so simply, so cleanly. RFRA does, right? Just a few sentences. And what RFRA did was, didn't restore religious liberty as it was in 1989. It restored religious liberty to what many lawyers would say was the high watermark in a couple of particular decisions before 1990. It restored the most vigorous version of religious liberty as it existed in the law before that. It did not disclose that to folks in Congress. The left and the right tended to agree about this, that this was just a restoration. And so it's one of the reasons the majorities were so overwhelming in favor of RFRA, is that no member of Congress wanted to be against religious freedom in the abstract, right? This is an easy statute to support. Left and right were saying, we're just restoring the law as it existed before this Smith case. And it doesn't, to vote for it, doesn't commit you to peyote use or being against contraceptives or being in favor of more religious freedom for prisoners. It doesn't commit you to anything except religious freedom in some abstract way, and then we'll let the judges figure it out, right? We'll punt it back to the judges. So the story was much more complex than it was told this morning. And the right to life piece had to do with the possibility that Roe versus Wade was going to get overruled. And some folks, including the Conference of Catholic Bishops, thought, whoa, if Roe and Wade is overruled, and now abortion laws, prohibitions will come back into play, and some women may claim the religious freedom to terminate a pregnancy. My pastor advises it, it's appropriate to my family, etc. And the Conference of Catholic Bishops did not want to invigorate abortion choosing rights in the name of religious freedom. So they opposed the act, and only when the Supreme Court in 1992 signaled that it was not going to overrule Roe versus Wade, the Catholic bishops dropped their opposition, the coalition came together, and the law went through. Okay, so that's just a story about how the law came to be. But the other very important jurisprudential piece for people to understand before we get back into the particulars is the difference between this statutory formula that we're talking about, substantial burden, compelling interest, very flat, very two-dimensional, and the underlying religious liberty principles that the Supreme Court had developed over the course of a century, which were quite the opposite of flat. They were rich and thick and three-dimensional, and they were driven by particular narratives about business, about prison, about the military, about particular claims. There's a rich narrative in that law that just got flattened out, right? So a lot of Hobby Lobby's arguments, quite appropriate lawyer arguments, are based off that flat version of what's a substantial burden, here it is, what's a compelling interest, here it's not, and that's the way they want to argue. Okay, so let me say a little bit more about the substantial burden piece, and then I've had more than my share, and I'll stop. There's two parts to the question about what's a substantial burden on religious exercise. There is the question of what is the secular or legal cost of complying with your faith. What will you have to pay? You have to go to prison, pay a fine if you comply with your faith. And there is the other side of the question, which is what is the religious cost of complying with the law? If I comply with the law, if I do what the law says, what is the religious significance of that? Now, on the first one of those, Kyle kind of skimmed past a part of the story a little bit, because the Green family and others in the same situation had and have a choice. They could comply with the law and include the contraceptive coverage, including the ones they object to, or they could make a $2,000 per full-time employee per year assessable payment under the Internal Revenue Code and drop coverage. They could drop all coverage, and then all of their employees would be free to go and buy policies on the exchanges, including getting subsidies when they were eligible for subsidies, and they would get the contraceptive coverage. Now, is that pressure? Kyle used the word pressure. Yeah, there's some pressure, but it's a complicated kind of pressure where some is, we're going to fine you if you offer the wrong kind of insurance policy, and the other kind is, well, there's competitive labor market pressure if you drop your health insurance policy, and then other businesses might be able to compete for employees. Okay, but that story's just a little richer and thicker than the way Kyle told it. On the religious cost of complying with the law, this is where I think a lot of people have a common sense intuition that buying an insurance policy that covers thousands of goods, only a few of which are objectionable, which your employees may or may not ever choose to use, does put the employer at some considerable distance from the choice to use those goods. It's not like an OB/GYN doctor asked to perform an abortion, hands-on something that involves potential human life or human life. So as a matter of common sense, everyday intuition, I think there's a question about what is the religious cost of buying that insurance policy when you're that disconnected from the ultimate choice to use. But here I'll concede, the law tends to be on Hobby Lobby's side because the Supreme Court has said pretty loudly, you can't second-guess believers on the contents of their conscience. Even if other Christians would disagree, even if some people don't get it, this is the way the Greens read Scripture, this is the way they understand it, and it's not up to the courts to second-guess on the meaning of religious questions, and I think that's probably right. So I'll stop there. Okay?
Does anybody want to address that particular aspect of the question?
we hear the claim many times out in public discourse about this. Oh, come on, this is so attenuated from the actual delivery of these services that it seems that this is absurd that the Greens and others would object to this delivery. What's the best argument back to that, that this is in fact something that would make the Greens complicit?
Do you want me to pick up, or do you want to pick up? Please feel free to add whatever. The argument is pretty clear on this. We're talking about drugs and devices that Kathleen Sebelius herself testified before Congress act after an embryo has been formed. Okay, so that's clear. It's also in the Food and Drug Administration's material on it, and the instructions for these. Planned Parenthood itself has a website about pregnancies with your IUD in. I mean, it's pretty clear that this can act after an embryo has been formed. And frankly, also the consensus about whether or not we're talking about, in the case of emergency contraceptives and IUDs, something that the scientific community generally understood to act to destroy a new life. It's really pretty clear. Anyone who wants to read about it, the best account is in Germaine Griset's book on abortion. He summarizes the meeting at which the birth control industry decided to change the rhetoric of pregnancy from conception to implantation. And he goes through the whole meeting. They said it would be a lot more convenient to do that, and it would upset people if we just changed that definition. So all of this is to say that it's pretty clear that these drugs and devices are acting on an embryo already formed. And I always like to throw in Germaine Greer's point on this, the very renowned feminist who said it's really not fair to tell women there's no difference between these kinds of drugs and devices and others that act before an embryo has been formed. So it's a pretty big dividing line we're talking about here. We also have the Christian teaching, very classic and very, very well developed. The Religious Freedom Restoration Act would have no trouble finding that this was a sincerely held religious conviction. And it's very well developed in the literature, at very high end, scholarly and theological literature, regarding what we call moral cooperation. The government uses the language of attenuation, but the theological problem here is moral cooperation with specifically including the government through HHS, which then relied on the Institute of Medicine, is specifically naming these particular things. This is not just one thing among many, many others. In fact, the government's pushing so hard back on hundreds of plaintiffs and dozens of lawsuits, has highlighted the witness value of this to a dramatic degree, such that a firm that went along with this now would be making an even more clear statement of cooperation than they would have previously, it seems to me. So we're talking about a grave matter. We're talking about what is called in the literature material cooperation, that the people who act in the corporation to tell the third party, I won't, this is for the religious institutions, I won't do it, but you do. But for a family like the Greens and others who are religious families running for-profit corporations, I specifically, making insurance decisions include this. It's just not even a question whether in the theological literature this constitutes a cooperation with a grave evil. So I think that's pretty clear, and I think the government really isn't going to be able to get past that.
Can I just add a couple of things to that? I agree with all that, Helen. So it's the idea of if somebody looks at this and says, okay, it's about moral complicity, but it seems attenuated, and so what are you complaining about? A couple of things. I mean, Chip hit on one of the points, which is it's none of the government's business whether their theology is right or not. As a matter of fact, the government doesn't have any business going into court and saying, well, you got your theology kind of wrong. The government tried that.
And the courts have been very clear
the courts have been very
staying
clear
out of
about
those
that.
kinds of
And on
judgments as
things,
well.
frankly, far more attenuated than this. I mean, the Thomas case is about working in a certain kind of foundry that will eventually produce a tank that will eventually be used in Vietnam that may kill somebody. Right. And the Jehovah's Witnesses claim, the court said, we're not going to second guess that. But, you know, in a sense, that's too weak of a point because this is really not a far-fetched claim of moral complicity at all. What I'd like to ask the government is, if this is attenuated or this isn't really a cognizable moral problem, why have you exempted all these religious employers? Why have you gone out of your way to say, okay, if you're a religious employer and we think you you employ a lot of religious people who agree with you, we're not going to make you do this. Okay, now I suspect the government would say, well, we're just being nice, or we're just being politically savvy, or we're just kind of, I don't know, it just seems right to us to do that. But I'd say to them, no, implicitly you're recognizing there's a moral problem that's caused with this insurance. Why have they accommodated, or at least pretended to accommodate, with so many nonprofit religious entities like the Little Sisters of the Poor, if they don't recognize that there's a real moral problem here? And the last thing I would say is that if you read the fine print in the Federal Register, which I admit is not something that I would recommend, but if you do that, you see what the government says it's trying to accomplish here. It's trying to put specific drugs in insurance policies. Why? Because it wants them to be used more often and more effectively. So if some of those drugs are abortifacient drugs, which the government admits, it doesn't use the word abortifacient, but admits the action of the drugs, the government wants those drugs to be used more often and more effectively, and it wants to make the people like the Green family cooperators in that. And it doesn't seem to me to be far-fetched at all for somebody to say, look, I don't agree with your policy. I can't stop you from doing it, but don't make me a part of it.
So let's hold off on the question about the so-called honeycombing of the fact that there's so many exemptions that seems to deflate the government's claim, and ask the question now, if this, it was interesting to hear Judge Starr say essentially what you said, which was that the substantial burden question really isn't an interesting issue here. But because in some ways we are deferring to the claim that there's a substantial burden. But of course what RFRA does is say that if there is a substantial burden, the government's interest may still be compelling enough to override that burden.
I think the substantial burden argument hasn't been made on this panel yet. I don't think,
great.
listen, it's not an argument that I would start out defending, and I don't think, but I think someone should at least make the argument as devil's advocate, so let me rehearse it anyway.
Devil's advocate.
Just so that, yeah, I mean, this is not an argument I would want to stand the case on, but I think someone should at least air the claim. What the government is saying is, being compelled to buy contraceptive coverage as part of a general insurance package is a lot like paying wages to your employees. Your employees get to make some choices with how they use those benefits. And in that sense, health insurance is just like part of their general benefits package. And they make a further claim, which is, if you look at other aspects of the religion clause jurisprudence, that is the First Amendment jurisprudence, we have some principles to guide us here. If I, for example, am a municipal taxpayer and I object to the way that the government uses some of my money in order to fund religion in some way, right, that it wants to promote religious speech or religious symbols, what the court says is, you have standing as a taxpayer in some of these cases to object, but if your tax money is being funneled or channeled through some third party's decision, right, if I have to pay for a voucher, for example, and some parent or child uses that voucher for religious education, and I object in conscience to the kind of education they receive, so I object maybe because I don't like the school they're going to or something, or maybe I think the school is teaching horrible things, religious hatred even, right? I might say, look, I object in conscience to the way my money is being used. And what the court has said is, you don't have a claim. You don't have a claim because that decision is being made by the parent or student. You don't get to make that decision. Now I say, no. The way this works is I have to pay for something that it's foreseeable that it might cover these things which I don't like. And even though somebody else gets to make the ultimate decision, we know that some people are going to make those judgments. And the court says, that doesn't matter. Right? You're being asked to pay for something, but somebody else gets to make the ultimate choice. If you take that principle from the Establishment Clause context and apply it here, right, in the Free Exercise Clause context, or under RFRA, it seems like the same idea ought to hold. And I think that's the nature of the substantial burden argument, the attenuation argument. You're too far down the line, or the decision is being made too far away from your contribution to it. That's the way that argument gets worked out.
And Micah, you've written about this, and could you explain a little more about the way that some of the court precedent backs up that claim, particularly the outcome of U.S. v. Lee in particular?
Well, United States versus Lee, I think, is something we should have a more general conversation about. But this case involves an Amish employer who objected to paying for Social Security taxes. What he said is, in the Amish community, we take care of our own. And we don't have to pay into Social Security because our community takes care of its members in their retirement and their golden years, and we never draw on Social Security, and we should not have to pay into it. And the Supreme Court said that claim for exemption is overridden by the government's compelling interest in promoting uniform application of the Social Security system. You have to pay into the Social Security system. There are no exceptions. It turns out Congress did eventually create an exemption for the Amish, only for those members of its own community, not for employees who are outside of the community, which is very important. But here, the court recognized that there was a burden on the Amish employer. So that's an interesting, it's an interesting tension in the substantial burden argument, I think. I think Hobby Lobby rightly makes a good point of this. There is case law for them to argue for substantial burden. In that sense, I agree with Chip and Kyle. I just want to air the argument on the other side. I think it's important to see what the government is trying to say before we say, this is so easy.
Sure, so what do we then make of the claim that the government has a compelling enough interest in enacting the Affordable Care Act and the contraception provisions as part of the preventive services, which overall may decrease overall health spending and increase healthcare efficiency, among other things? Does that rise to the level of compelling? Earlier in the previous panel, President Starr seemed to suggest, no, it doesn't rise to the level. Professor Dershowitz may have gone the other direction. So where do we assess those arguments? Helen.
I wrote my whole brief on this area, and so I'm really going to try really hard to be brief. The claim for compelling state interest here that the government makes is, first of all, at a pretty high level of generality, right? They're saying it's gender equality and it's public health with respect to women. The problems with that are really legion. A couple of things. To start off with, if you look, by the time this case gets to the Supreme Court brief, the government is actually arguing that children will not be born from unintended pregnancies, and that this will be good for children because we won't have children born with smaller pregnancy intervals, their birth weight, and other things about children will be improved. Now, it's curious for a couple of reasons. Number one, the mandate that Congress gave to HHS, who then turned to the Institute of Medicine for its report, was about preventive health services for women, not with respect to preventive health services for children. So that's just an interesting wrinkle. Number two, the argument boils down to preventing children from being conceived, or once they're in embryonic state, having them destroyed, is a children's health argument. So that's very unusual. Number three, the arguments they make about children's health. I went line by line through the IOM report and Health and Human Services, and every single scientific source they cite and unpack them, and they actually don't have the scientific argument even about the children's health. Second, about women's health, and I'll just confine my few remarks to what is at stake here in the case that's being argued tomorrow, because it's about drugs and devices that act on an embryo. Couple of things. With regard to public health for women, these are really contested medications and devices. It's not only all the lawsuits that have now run into the hundreds and hundreds of millions of dollars on some of these drugs and devices because of their negative health impacts on women, but I think most interestingly, it's the fact that no study of these devices or emergency contraception, not even one, as acknowledged by the leading researcher on this, James Trussell at Princeton, shows a causal relationship between more usage of them and less unintended pregnancy or abortion. None. There's not a single study. And you have to show causation in the compelling state interest analysis, that this is a strong state interest because it will help bring about the results that the law intends. These studies just don't exist at all, and probably because of what Janet Yellen, our new Fed chairwoman, has identified as the phenomenon of risk compensation when she and her husband wrote precisely about the proliferation of contraception and abortion in society, leading to a risk compensation effect, which we've seen with emergency contraception, of more, not less, unintended pregnancies and abortions. It's stunning. You can see this argument also plays out with other contraceptives, but with emergency contraceptives in particular, the data is really, really clear. So the compelling state interest argument doesn't work there. Also on the argument about women's health, all the citations that they attempted to make about the cost of contraception being something that impaired women from getting it or was related to gender equality, if you actually drill down to the sources they're all citing, the Medicare report on women's health care costs during childbearing years, turns out maternity is actually the biggest health cost differential, having the child, not contraception. Their data, there's no data showing that this represents the cost differential between men and women of childbearing age. Final statement, the gender equality argument. I started a group that ended up ballooning into 41,000 women without trying, who were really angry that the government seemed to be saying, and then when they were politicizing this mandate during various political campaigns, that women are not equal unless they enter society sort of childless, that being childless is something that has to be, that the government has to help women with, because then they can enter society on the same level as men. The statements on that in the government's briefs, all from the trial court to Supreme Court, disturbed enough women that they got together to oppose them. So it's not all women, but it's deeply divisive statement on their part. So.
Chip.
A couple of things. First, it's true that the two cases that are being argued tomorrow, and this has been said many times now, involve objection by employers to just a handful of contraceptive devices or services, not the full range of them. But, Kyle knows this extremely well. Some of these were his clients when he was at the Beckett Fund. There are many, many, many cases in the lower courts where the employers are objecting to all contraceptives, not just to these four. And I cannot imagine that Kyle, up here or anywhere else, you were going to say, oh, you know, those people ought to lose, right? Hobby Lobby should win, Conestoga Wood should win, because it's just these four. But the folks that object to the whole range of contraceptives, no, that's just too much. No, I'm sure you don't think
you're
that.
right. They should all win.
Right, you think they should all win. So when we're talking about this, let's not be fooled into thinking this is just about, not that these four are unimportant, right? Emergency contraception, hormonal IUDs, safe and effective and expensive, so that being insured or not insured makes a difference. But the other cases are about, many of the other cases are about all, not just these four. Second, I think there's frequently a subtle, it's either a misstating or just a confusion about how the compelling interest test works in RFRA and free exercise cases. The government doesn't have to show it has a compelling interest in the policy taken as a whole. It has to show it has a compelling interest in not allowing opt-outs. Government may burden a person's exercise of religion if it demonstrates that application of the burden to the person, making this company do this, is in furtherance of a compelling interest and is the least restrictive means. So the question is always about opt-outs. What are the interests at stake in opt-outs? And if we allow companies, some small, but some quite large in terms of number of employees, if we allow them to opt out under RFRA, we are going to have however many thousand women employees, however many more thousand female dependents of the employees, right, daughters, spouses, etc., whose insurance coverage will not include these particular goods and services. Now, they'll still be able to get them if they can afford them. Some people will be able to afford them better than others. If hormonal IUDs, which are not recommended for everyone, but if they are the safest and most effective for many women and the most expensive, it's really hard for me to understand the argument that these women aren't being harmed by losing insurance coverage for that particular service. So the government's interest in opposing opt-outs for religious reasons is to make sure that these women are not deprived of this kind of coverage. Just these goods, in this case, all of contraception in some other cases.
So that then sets up the question that was raised earlier about the so-called honeycombing, that there are already so many exemptions and exceptions made under the law that there are millions literally uncovered. So why not then allow an accommodation on religious grounds along with all of the other grounds?
Would you like me to answer that? Would you like someone else? Micah, you want to run that or you want me to run that?
Go ahead. You're
Go
on
ahead.
a roll.
You're on a roll.
Well, I think the most significant of those exemptions is the grandfathering of pre-existing policies. Right? You can keep the policy you have if you like it, right? We can make fun of that. But there's a policy in the Affordable Care Act that if businesses, employers, keep their pre-ACA policies, unless and until they change them, they can keep their prior coverage, which might, in some cases, exclude this sort of contraceptive coverage. So for some time, there will be women who are covered by those policies. I don't know how many don't get these particular services under those grandfathered policies, but that's the number that's not protected. This is a transition rule, right? This is an attempt to let businesses adjust over time. Anytime a business wants to go in the market and say, okay, we want different deductibles, we want more of this, we want more of that, we want to cover more dependents, they want to change their policy in any way, they got to buy a new one, and the grandfathering is over. And when the grandfathering is over, then these coverage rules kick in. So 2 years, 4 years, it's hard to imagine it's going to be very long before the number of women who are not covered by policies that include all pregnancy prevention services, that number is going to get smaller and smaller and smaller. So that's the government's compelling interest operating over time, not all at once. If Hobby Lobby wins the case, that's a permanent exemption. That's not a transition rule. That's as long as Hobby Lobby's in business.
There's a couple of
Micah,
things on
Kyle,
that.
I want to make one little
Yeah,
response.
go ahead.
Okay, Helen, quickly
No?
respond.
Oh,
One
I
little
think-
response, and then Micah and Kyle.
Thank you. I wasn't expecting to go first. Thank you. One problem, I think, with Professor Luper's argument is that when the government declares a benefit, some benefit, today it's emergency contraception or all contraceptives. Tomorrow it could be what everybody understands to be abortifacient. The day after that, it could be in an aging population, certain forms of assisted suicide. If the legal argument goes that once the government says this policy has to include this benefit, and that becomes the new baseline, then anyone who isn't providing that is all of a sudden given the label of depriving, taking away a right that the government just announced 5 minutes ago. I think that's a really problematic legal test, and I think the slippery slope on it is really bad.
So on grandfathering, just to respond to what Chip was saying, so grandfathering is that if you like your plan, you can keep it, right, provided you don't make certain changes to it. The interesting thing about, so what we're talking about here is the preventive services mandate, specifically the contraceptive mandate. Is it a compelling interest? Is it something that's so incredibly important that the government must override religious objections to it, right? So if you look at grandfathering, Congress made some prioritization when it did the grandfathering. It said, look, even if you're grandfathered, your plan still has to cover your dependents up to age 26, and it can't have lifetime limits, and no pre-existing conditions. That's Congress saying these things, these items, I mean, you've all heard about your kids now have to be on their plans up to 26, right? Your kids are happy about that. You're maybe not so happy about it. But Congress said, this is extremely important, and we're going to apply this even to grandfathered plans, so that however long this transitional period lasts, and it's indexed to medical inflation, so who knows how long it's going to last, right? And there are millions of plans that are grandfathered and will continue to be grandfathered this year and next year. But these Congress did make a sort of a set of priorities and said, look, these are important to us. We want these in plans now. And so it seems to me that then when you look at a regulatory agency like HHS, and HHS says, well, look, these preventive services mandate, this is important to us. Okay, but it's obviously not as important as what Congress said in the law itself. So that seems to me to be a huge blow against the compelling interest. There's no doubt that people think, many people think, that the contraceptive services mandate is important. There's no doubt about that. No one can test that. The question is it a compelling interest? And the other thing I would say very quickly is that Congress has to, the government has to prove that it's a compelling interest. The government bears that burden under RFRA to prove it. Now, if you look at the evidence in this case, all the government's put in is the Institute of Medicine report. And if you look at the 5 pages that are out of the 100 and something pages that are devoted to discussing the contraceptive mandate, what the government says is that there are certain women in a narrow age group and socioeconomic group who are at genuine risk of not having access to contraceptives unless they have insurance, right? Or unless they have some kind of help to get them. Now, the government has not bothered to prove in this case, have not offered one shred of proof that any employee working for Hobby Lobby or any similarly situated employee, right, any similarly situated employer, people who have full-time jobs, people who have generous health benefits already that cover 99.9% of all the preventive services already, that those people have a genuine economic crisis of access to contraceptives. I think the government has to put in something that shows that to even get to the compelling interest test at all, and the government hasn't done that.
Micah.
So I think this actually raises an interesting point about the way this litigation has gone so far. So the first thing is, the argument that's going to happen tomorrow is coming up in a very early posture. There have been no trials in any of these cases. There's really no facts in any of them, at least after discovery. So we don't know anything about the costs to employees except for what the parties have alleged in their briefs. There's been no testing of any of that. That raises, I think, a background consideration for this litigation, which is the posture of all of these cases, the structure of this litigation, is the same across all the cases, and that is it's a private employer versus the government. But there is a substantial constituency who will be directly affected by the outcomes of this litigation that's not represented anywhere in it, and that is the management and the employees of these corporations. Right? There are no employee plaintiffs, no employee interveners. We don't really know very much about the kinds of facts that they would bring into this litigation. And in some ways, I think it's a little bit early for the court to have taken up these cases without hearing from all the parties who will be affected by it. Now, the government has represented the interests, so to speak, of some of these employees. And the way that it does that is by framing its compelling interest, I think, partly in the form of a claim about women's health. That's important, obviously. But there is a larger consideration here, and that has to do with concerns that sound in the Establishment Clause, something that we haven't talked at all about so far. The Religious Freedom Restoration Act was meant to restore a standard under the Free Exercise Clause. But there are two clauses in the First Amendment. The second clause is the Establishment Clause. Congress shall make no law respecting an establishment of religion. And the Supreme Court has interpreted the Establishment Clause to impose certain limits on religious accommodations. And one of those limits is that accommodation should not impose significant burdens on third parties, what the Supreme Court calls third-party non-beneficiaries, that is, people who don't otherwise benefit from the accommodation. What the government is arguing here is that allowing Hobby Lobby an exemption under the Affordable Care Act would shift the costs of paying for contraception from Hobby Lobby or other corporations to their employees, effectively requiring their employees to subsidize the cost of Hobby Lobby complying with its religious observance. For almost all employees in this country, save for those who are employees of religious nonprofits, they have a statutory right to receive these benefits as part of their employer-based health insurance. It would only be these employees, subject to an exemption in cases like Hobby Lobbies, who would have to pay for this. That is the first compelling interest that the government articulates in its briefs at this point. That is, what Hobby Lobby is asking for would shift the costs from the employer to the employee. And it's that cost shifting which raises a concern under the Establishment Clause, forcing employees to pay for their employers' religious beliefs and practices. Now, that argument might, at the bottom of it, rest on claims about women's health, but first it rests on this concern about who pays for religious exemptions. As I said, employees aren't in this litigation. They can't come to the government and say right now, look, we didn't choose to organize health insurance the way that the government did. We're stuck with this just the way that Hobby Lobby is stuck with this. But we have interests here too. And I think it's unfortunate that their voices aren't heard independently in this litigation.
Great. So we're sort of remembering time. We have about 20 minutes before we open it up for questions. So there's a couple of very substantial questions we still haven't addressed yet. One of which some people say isn't really even an issue here, although it is the thing that's really sucking up a lot of the oxygen in the conversation. And that's this question about the particular for-profit kind of business that is claiming this right of religious freedom or religious liberty. It is the corporate structure. How can a corporation claim to exercise religious liberty such that the court should grant them an exemption or an accommodation under this law? Is there something about entering into the stream of commerce that is different than being a social service agency or a religious institution that can gather individuals around a sort of common cause that makes for-profit businesses much more susceptible to government control and regulation than other kinds of social institutions. Chip, do you want us to get us started?
I think a startling amount of time has been wasted on this particular question, okay? I really do. I think that in every case, the question should be, what is it that the corporation wants as a matter of its religious freedom, and what are the consequences of it, right? That's the argument Michael was just making. I share his concerns that there's an Establishment Clause problem about shifting the costs of an employer's religious convictions to its employees, okay? But we can imagine, there's so many ways to think about this that push you out the other way on the question of corporate conscience or religious freedom. First of all, I'll bet you half the people in the room, have investments in some sort of social investing fund where you care about the corporate moral conscience. It's Whole Foods and we do free-range chickens, or there's vegan restaurants and all kinds of enterprises that have corporate identity, and they have moral commitments to that corporate identity. And I think most of you wouldn't blink at the thought that a corporation could have moral commitments and a moral identity. And, to go back to some things we talked about this morning, if it were, an Orthodox Jewish merchant who was closing on Saturday, and the business was in the corporate form, and the state said, no, in the business of selling meat or whatever it is, you must be open on Saturday, would we really say, oh no, too bad, you incorporated, and so you're stuck with the law? If only you got rid of your corporate status and became an entrepreneurship or a partnership, then you could complain about the law. That doesn't make any sense to me whatsoever. What makes sense is to look at exactly what the corporation wants to do and ask whether this is something we're going to recognize it's right to do. And that's what we've been talking about up till now.
I couldn't agree more with what Chip just said. I was in Whole Foods yesterday paying too much for cheese. And I walked by the Fair Trade coffee stand and resisted the temptation to pay too much for coffee. But the slogan over the Fair Trade coffee said, caffeinate your conscience. And I said, okay, the Whole Foods is talking about my conscience. Whole Foods has a conscience. I heard this rumor when we brought this lawsuit that corporations can't exercise religion. And I went and looked at the case law, and I found no case that could ever say that. In fact, I found tons of cases that said that nonprofit corporations exercise religion all the time. I also found cases that said individuals can exercise religion even when they're in the midst of commercial pursuits. Sometimes, as in Lee, which I hope we get to talk about soon, sometimes they'll lose. But there's no doubt that they're exercising religion, and that commerce doesn't sort of collide with religion and dissolve it like acid, right? There's no precedent for that whatsoever. And so I agree with Chip that an astonishing amount of time has been wasted on the argument that I think Hobby Lobby
Michael
should
wants to
really
dissent
win.
on this.
Fairness, let me waste a little more time.
I'd like you to wait.
Alan, I actually don't want to stand on this argument either. I've put my name on a brief about the Establishment Clause concerns and about the substantial burdens on employees. I think this case, for me, turns on those kinds of questions. So I wouldn't, at the end of the day, make decisions on this basis. But I do think, again, these arguments have convinced appellate courts in various parts of the country, and a lot of other people in this nation are convinced that corporations, especially large for-profit corporations, don't have rights of religious liberty. And I think we ought to at least understand what their argument looks like. So here are a couple ways at it. As a matter of law, there's also no precedent on the other side. There's no precedent that says a large for-profit corporation has rights of religious conscience. No Supreme Court case is on point. There are cases involving sole proprietorships like Braunfeld, like the Amish employer in Lee. Yes, that's true. And there are cases involving nonprofit religious organizations, churches, who everyone acknowledges have free exercise rights. The question is, why do they have free exercise rights? One distinguished answer in our history is that they have free exercise rights because churches are understood as voluntary associations, going all the way back to our framers and beyond that to John Locke and other theorists of religious toleration. Churches are voluntary associations in which people come together who share religious values, and the church represents their values and interests, and it stands in their shoes, so to speak, to assert their rights of religious conscience. Individuals have freedom of conscience, and churches represent their freedom of conscience sometimes in litigation. No one disputes that. That's, I think, a matter of wide consensus in our society. But that's on one polar side of the spectrum. On the other side of the spectrum is, say, Walmart, right? Large, publicly traded corporation with millions potentially of shareholders. Can a corporation of that kind assert the religious interests of its constituents? not only of its owners, but maybe of its management, of its millions of employees, and so on? How are we supposed to think about claims for religious liberty of corporations of this kind? And in some ways, Hobby Lobby is an easy case because you've got a closely held corporation with a very small number of owners. What happens when we start to expand the number of owners? What happens when the owners disagree about the nature of their religious beliefs? What happens when we have proxy battles over whether corporations ought to engage in religious practices or not? Should we attribute religious liberty interests to them? These are very, very complex kinds of questions that if the court finds that religious corporations have free exercise rights, we're going to have to think about those kinds of questions in a lot more detail and a lot more complexity than we have so far. There is a serious challenge and a serious set of questions that arise under this. I would beg to differ with Professor Dershowitz and with Judge Starr that no rational person could take the other side of this. In fact, a lot of rational people have taken the other side. A lot of federal judges have taken the other side, and I won't be surprised if some of them do tomorrow as well.
Helen?
One quick response to that. Just this description, particularly when you get into the question of large corporations and shareholders and large body of management, it crosses over into the question about the alleged parade of horribles that follows if you allow corporations to do this. And I think Micah's points really make a point that, or move toward making a point that I wanted to say, which is the idea that somehow allowing corporations to have conscience is more problematic than it is good, right? So Kyle has sort of put out the it's good, and we like it, and we like to do business with them angle briefly. But the idea that you, in the future, if for-profit corporations were allowed to exercise religion, you'd still have to find that they were exercising religion, that it was religion, not something else, that it was sincere. And then, of course, the government still can come back with its compelling state interest. So the idea that the parade of horribles follows instantly from answering yes to what is often seen as the first question in this, which is, can a for-profit corporation have a conscience? It doesn't play out. It is indeed a complex question, depending on the nature of the corporation, how they exercise religion, although I think Professor Lupu's statement earlier about what is it that they're doing, is it religion, maybe the easier part of it than what does it look like when they exercise.
So is the only thing holding back the floodgates of that parade of horribles the government's interests? So that's, in other words, your argument again about why race and gender, for instance, might not be then grounds for claimed exemptions under RFRA if Hobby Lobby turns out for the Greens.
Right. I don't think that's the first hurdle of the government's compelling interest. You've got the fact that you already have a variety of these civil rights laws, Americans with Disabilities Act, pregnancy discrimination, Title VII, et cetera. And it turns out companies actually want to do business with us. And they aren't looking to discriminate against people they're doing business with or people that they wish to hire who are qualified. So you don't have the parade of horribles in the past. What they have, however, brought a lawsuit when the government said, insure for this particular thing. And then second, of course, you do have a very robust argument, and historically, on all of these variety of non-discrimination points, race, gender, et cetera, that are not in the way that particularly emergency contraception and other forms of contraception, if we got to that, are contested.
Well, or the alternative is to look at that history as, you're further down the chain or the Enlightenment has proceeded past you on race and gender, but you're still back here thinking that women should be at home and you don't want to hire a woman to do this job, or you don't want to sell these products to women because you don't think women should be in commerce. Chip, do you want to?
Oh yeah, the cutting edge case here, it could be about, a single pregnant woman or single mother, but I think the cutting edge case we can all see coming is if Congress enacts ENDA, right, adds sexual orientation to the federal law about employment discrimination, and if Hobby Lobby wins this case, I have no idea what its attitude would be about covering spousal benefits for a same-sex spouse. But around the corner, many more states, by court order, by legislation, recognizing same-sex marriage, and there will be litigation about hiring, firing, refusing to hire, and especially about refusing to pay spousal benefits in the case of same-sex spouses based on religious objections to that form of marriage. That's coming.
Right. So as a way of wrapping up our discussion, I want to sort of pose the question, not how do you think the court is going to rule, because I don't think anybody can really judge that. What is the future of religious exemptions in your mind, given how the court might rule? If the court rules one way or the other, where are going to be the critical issues, the places that we're going to see the flashpoints? Chip's already talked about same-sex marriage. We just saw this in some of the state anti-discrimination laws and the state-level RFRAs, which almost every state has a RFRA that was passed almost simultaneous to the federal RFRA. Where do you see the problems emerging, depending on how the court rules? Let's just go down the row.
You know, one of the beauties and the devilish qualities of RFRA 20 years ago is that everybody agreed not to think down the road. Like, ooh, what are the bad religious freedom claims that are going to come? They're going to be about drugs. They're going to be about gay rights. They're going to be in prison. Let's like all just hold hands and jump off the cliff together, because we think that there's something at the bottom of that. You know, the courts will like knock out the bad ones and save the good ones, and it won't be perfect, but we're better off with it than without it. And I think that's always a law like RFRA, which is so general, very different from a practice-specific accommodation, right? Everyone has to cover employees, but churches don't, right? We can all see that's very bounded and confined and particular. But this kind of general law that opens it up, I think this is going to be on the court's mind, very much on the court's mind tomorrow, right, in the way they decide this case. And it may influence them on can corporations bring the claims or not, or I certainly think it's going to influence them on the point that Micah and I have pressed about third-party rights, about the rights of employees. We don't want to empower corporations to have all this leverage over employee benefits, minimum wage, maximum hour, non-discrimination as a matter of religious freedom. But nobody knows 30 years from now what we're going to be fighting about on these kinds of issues.
Helen?
I would disagree on the historical point about the Religious Freedom Restoration Act, because the attempts to have civil rights, non-discrimination carve-outs were turned back. They knew that they were going to face them in the future, I think, and they decided to allow the compelling state interest analysis to play out, although then I agree with that part of Professor Lupu's analysis that says they were going to wait and see how that played out. But they knew the civil rights challenges were coming, number one. Number two, I completely agree with your point about same-sex marriage. Less so about people of various sexual orientation. The objection is not about people, it's about an event. It's about an institution, which till about 5 minutes ago, in historical terms, the Supreme Court, every single case they had ever covered on state marriage recognition, understood it was related to kids. So again, that's new. The whole question as to whether that is a civil rights non-discrimination claim, this very recent same-sex marriage phenomena. The final thing I would point out is I'll be really interested if they do end up getting into if there is more protection for acknowledged for-profit entities, religious freedom has a higher profile. If we're actually going to see some better empirical data from the government than I've seen so far on the compelling state interest stuff, I think they're getting away with sort of an evangelization on emergency contraception and contraception, with arguments that just play to politics or ideology, but they really haven't made much of a science argument. And so I'm going to need to see if they're going to step it up on the compelling state interest analysis, because they might be compelled to if religious freedom is more protected.
Micah?
If for-profit corporations can make claims for religious exemptions, I think we see two growth areas in terms of litigation and questions. One is, what counts as a significant burden on people who don't benefit from the exemptions? That is, what would justify a compelling interest of the form that the corporation is shifting costs onto its employees in a way that would cause courts to restrict those exemptions? Maybe an exemption over 4 abortifacient drugs, if they are that, wouldn't so burden employees as to create this kind of concern, but lots of other claims for exemptions might well do that. If Hobby Lobby wins its case, I think we're going to see a lot more cases testing the boundaries of that cost-shifting principle. The other question, I think, that if Hobby Lobby is successful, the other question that's raised is, what about people's consciences who, where they're not strongly motivated by religion? What about what was the line about caffeinating your conscience?
Yeah.
Whole Foods.
Right, Whole Foods. I don't know if Whole Foods is religiously motivated or
doubt
not. Maybe not. But and Professor Dershowitz made a point about this earlier. what are you going to do with people who make claims of conscience where their consciences don't sound in traditional religion? Is RFRA going to cover those kinds of people under the principle that the Supreme Court articulated in the Vietnam draft protest cases? If you're even vaguely religious, or even if you're not religious, but your claim sounds in conscience of the kind that would be familiar to somebody who's traditionally religious, are those people going to be protected? Are they going to be protected when they own for-profit corporations? Those are all questions, I think, that are coming eventually.
I tend to agree with everything I've heard here. I think one point that I would make is that we can't forget that the crisis that caused the Hobby Lobby case to come about and all of the other cases, including the nonprofit cases, is not employers deciding to just withhold benefits from their employees because they're mean, right? It's because the government is forcing them to do it through a very large national health insurance law. So the idea is that if the government is increasing in this way and becoming more and more sort of intrusive in the way we order our lives together, then we should, I would think that people who are interested in religious freedom would welcome challenges under a Religious Freedom Restoration Act, whether it be a national or a state RFRA, to sort of test the boundaries of what the government can make us do and what the government can make us not do. Sure, that when the government says you're going to give this to this your employee, or you're going to give this to this other person, or you must provide this service to these people, if there's a resistance to that claim on religious grounds, then sure, somebody's not going to get the service or somebody's not going to get the benefit. Somebody's going to be able to say they're a loser in the process, and somebody's going to be able to say they're a winner. But we're talking about religious freedom, and at least in 1993, it seemed like we had a very robust commitment to the principle. Maybe Chip's right that we didn't foresee all the different little Rubik's Cube permutations of the principle, and I don't think we're ever going to be able to see all that. But the question from my point of view is, do we have a commitment to religious freedom as against government imposition on people, and how are we going to work that out? Are we going to work it out in the court system with a thumb on the scales very strongly, as I think our traditions are, in favor of the sincere religious believer? Or are we going to have some other system? And I certainly hope that we continue along the path of the Religious Freedom Restoration Act, and whatever the outcome in the Hobby Lobby case, and I certainly hope we win, but whatever the outcome, I hope that everyone takes away from this case that religious freedom is a robust, real commitment that we all should make to each other.
Great. So we have about 15 minutes for questions. I ask that you introduce yourself, be exceptionally brief so that we can distribute questions around the room, and speak in. There is a microphone with a fine young Georgetown student bringing it around, so please wait for the microphone. Yes?
I'm not a fine young Georgetown student, although I used to be a Georgetown student. My name is Scott Hamburger. I'm the CEO and co-founder of Integrous Holdings. You hold the mic. Hello, hello. Working again. My name is Scott Hamburger. I'm the CEO and co-founder of Integrous Holdings, Inc., which, like Hobby Lobby, is a family-owned business. And knowing that the Greens are in the room, I take this opportunity to salute you. More than most in the room, I understand the gut-wrenching choices that are involved in staking your business, your personal reputation, and your fortune on doing the right thing. So agree or disagree with the Greens, one has to admire them. In listening to the panel, and for the record, our company has taken no position on this matter. But I do believe that companies are moral agents, and therefore this kind of question has significant implications for business people, particularly family business people. In listening to the discussion from the dais today, I'm struck by what seems to be missing. There's a lot of talk about a theoretical relationship between a company and its employees. And Professor Dershowitz made the statement that his wife chose to go to a Catholic school or a Christian school, and therefore a certain amount of Christianity was okay. We have a relationship of choice with our employees. They choose us, and we choose them. And it's not a theoretical relationship, it's a real relationship. So the notion, for example, that we should simply drop them to the tender mercies of a health exchange and just suffer a $2,000 penalty is a highly charged, it's a moral decision for us to do that. Could we save lots of money? We certainly could. But morally, are we willing to throw them to the tender mercies of that system to see what happens? The point to which I'll arrive momentarily, is that I admit that I'm nothing more than a simple businessman who has to worry about making his way in the free market and making payrolls on Friday. But what seems to be missing to me from this discussion is the notion of that relationship between us as employers and our employees who choose to be with us. And if we fail to provide a benefit that is oh so valued by those employees, certainly they will vote with their feet and leave. So I do not believe they are silent. I believe they are represented in the free market of employment. And please educate me as to why that issue of employee-employer relationship has not come into the discussion from the dais today. I'm certain it's simply because I'm missing the intricacies of the case.
Chip, Micah, do you want to?
Well, I missed the beginning of the remarks, all right? So you said are you a businessman? Is that what's at the beginning?
Correct. I'm a co-founder of a family business.
You're in a business. Okay. So, listen, I don't know how many employees you have. I don't know what your relationships are. You speak as if you're someone who cares deeply about their well-being, and we'll take that in good faith. I still wonder, if the Affordable Care Act had left it to you and your employees to negotiate the contents of the health insurance policy. Are your employees unionized? What kind of bargaining power would they have? What would they push for? What would you push against? Would you not want to cover certain high-end expenses? Would you not want to cover plastic surgery because you have some concerns about it or principles against it? So we'll accept that you care about the people who work for you, and they care about you, and they also care about themselves. And so we have some choices. Either we let it just go to bargaining, and maybe it'll come out however it comes out, or the government specifies minimum coverages because they think that's what everyone should get. And there are plenty of people who think that the Affordable Care Act would be better if it was Medicare for all, single payer, let it just run that way, but it's not the way it runs. So it's left in the employer's hands to decide how to manage that. But this Hobby Lobby case focused on particular goods so suggests a kind of cafeteria idea where somebody's picking and choosing what's in the coverage, and I'm not convinced that's a good general policy, religious freedom aside.
Anyone care to add? Sir.
Hi, I'm Charles Arian. I'm also a former Georgetown student. I'm a rabbi in Gaithersburg, Maryland, and my first job, I was the Hillel rabbi at UVA, so I'd like to also say go Who's, wahoo wah.
Wah.
My question is, if Hobby Lobby prevails, would a logical corollary be a successful claim by a Jehovah's Witnesses-owned company not to provide coverage for blood transfusions, or indeed a company owned by Christian scientists not to provide medical coverage at all?
We hear this we call it the parade of horribles. I don't mean to sort of denigrate the question, but that's what we tend to call it. It's the parade of, if they win, then this will happen, and this will happen, and this will happen. Look, there's lots of responses to this. I think one of them is RFRA has been around for a long time. Where are these claims on behalf of the Jehovah's Witness and the Christian Science employer? I've never heard of one. So I tend to think these are truly hypothetical claims. If such a claim was made and the government, had a blood transfusion insurance mandate or something like that, one would think that the government would have powerful evidence that is a compelling interest, that it must have that mandate, and that it wouldn't have a grandfathering exemption, for example. It wouldn't say, well, if you haven't made certain changes to your plan, you can avoid the blood transfusion mandate. I just cannot imagine that state of affairs. So I think a simple answer, maybe it's too simple because I haven't seen that claim yet, and I don't know what evidence it would involve, is that the government would, if such a claim ever arose, which I think is highly doubtful, the government would probably win.
Micah, Chip, Ellen?
Let me make one small point. I agree with Kyle. The government would win. Those are cases where maybe life and death at stake in the provision of basic medical care or blood transfusion. But I also think there's some theology going on here about which faiths, and this is a theological choice. I'm not objecting to it. I'm just noticing it. Which faiths will say, listen, for us, we can't do this. We can't take blood transfusions. We won't give our children blood transfusions, but we don't object to others having them. We'll fund the insurance policy that lets our employees have them. because that's their matter of choice about health and faith. And these cases, the contraceptive cases, involve faith choices about what others are going to do, not just what employers want to do as a matter of religious conviction in their own health care. And that's a big difference between the two categories of cases.
Ma'am.
I think I might be able to speak
Could you,
loud enough.
if you could wait for the microphone so it's recorded.
I was wondering what the portion of the what the Hobby Lobby people pay now currently per employee for health insurance coverage, which they do have, I'm sure, as compared to the fine, the $2,000 fine. And I was wondering if that was relevant, and what portion of the ACA costs cover abortifacients, and what portion covers the birth control? And is there some way that could be accommodated in some way?
I don't mean to evade the question, but I
That's
certainly...
private information.
Yeah, I certainly don't want to talk about sort of confidential information, but I will answer it this way. The idea of simply just dropping insurance, which is that's what the $2,000 penalty goes toward. If you drop insurance and your employees go on the exchange and get some kind of subsidy, then you have to pay a $2,000 per employee penalty. You know, it's always been clear.
Relative, yeah, how good is their insurance versus the
Well,
drop?
that's an issue of just sort of, as someone said, you know, throwing them out on the tender mercies of the health insurance exchange. But the other issue has always been very clear, and the government's never contested in this case the idea that would be sort of catastrophically disruptive to the business and to its relationship with its own employees who have, you know, after all, we have an employer health insurance system. We've had it in this country for a long time, and it's underwritten by the tax code, and there are reasons why we have an employer health insurance system. There's reasons why we've come to depend on it. And the government in this case is saying, we're not going to create an alternative system for contraceptive benefits or other health care benefits. We're going to glom on to the employer health insurance system and make you part of that because it's, frankly, it's the convenient way to do it, right? So, you know, and so I think I'd answer it that way.
Sir.
Galen Carey with the National Association of Evangelicals. There was quite a bit of talk about the alleged cost shifting and employee burden, but isn't it the case that the Affordable Care Act created a regulatory burden on the employer, and so if there's an exemption from that burden, doesn't that just bring us back to where we were before the ACA was put into effect, and so there shouldn't be really any cost shifting implicated?
Yeah, the question of cost shifting, it depends on what your baselines are, right? So the first thing is to say that you could say, according to Alan Guttmacher Institute, who's commonly cited for coverage, you know, about 90% of employee policies cover this. So really what the ACA has done via this regulatory provision is shift the cost onto employers. It will be factored. So the first cost shifting happened there. And then the other point to bring up here is the Cutter versus Wilkinson point, right? The Supreme Court takes a look at the application of the Religious Land Use and Institutionalized Persons Act and says, wow, it's an accommodation. Is it an establishment? The question that Micah has raised here. And says, if the government has created the burden and then they decide to accommodate it, so long as they do so in a non-denominationally, you know, in a way, and that they don't burden non-beneficiaries unacceptably, this is okay. So you're fighting over baselines here as to what burdening non-beneficiaries is. And I'm suggesting that not only because of the data that I put out about, gee, what's this really doing for people in terms of lowering unintended pregnancy, or all the government's data on women's health and connected with unintended pregnancy has no causal material in it. So even if you set that aside and you just ask the question, what is the limit to the government declaring a benefit and then saying your refusal to give it is shifting the problem onto non-beneficiaries? That, to me, I think is one of the most interesting questions here.
I agree it's interesting, but I think precedent resolves it, which is the baseline is the statutory right that's provided by the Affordable Care Act. It would be like in United States against Lee, the employer says, well, you shifted the baseline when you created the Social Security system. No court, I think, will buy that argument that there's a baseline shift because the statute came into creation. We have all kinds of statutory rights that attach to the employee-employer relationship, and this is one. The fact that it's new, I don't think changes anything. It's just like all of these other kinds of statutory entitlements that the government has created, and I don't think that can be the principle that statutory rights don't change baselines. I don't think that can be an intelligible principle for determining when employees are burdened by exemptions.
I would disagree with that reading of Lee, however, which I don't think was about shifting a cost onto employees, but rather the employer getting exempted from what they referred to as a large, uniform, actuarially complex tax system. Versus here, what I think is a private-to-private transaction, company to health insurance company, and the question of the employee who will have to pay more for contraception versus less now, I think that's a very different question than Lee.
Well, we have drawn to the close of this panel. I expect everyone will be looking forward to the oral argument tomorrow and learning that we know nothing about how the court will rule on that basis. So we will have a number of other months to wait for the outcome. I wish you to join me in thanking Chip, Helen, Micah, and Kyle.